Blog Talk Radio.
Hello, fam. Welcome to Rachamah's Conscious Couch. I have a special gift for you today. We're going to go over some not only common law, but versus civil procedures. So we have the Honorable Al Bey Esquire and affiliates as our special guest today on the show. So this is going to be a special treat, and we're going to really be audience engaged today. So light up the switchboard, dial 310-982-4184, and press the number 1 and I believe pound in order for you to get in queue and speak to the host and our guest. It gives you the opportunity to run by some questions with some issues that you have that is going on with you. We're going to run some commercials at the beginning as usual at first, and when we return, we'll go more into who is the Honorable Al Bey Esquire and affiliate when we return. Right after the commercial break.
Calling all singers, rappers, musicians, and entertainers. Y'all Heard Radio has radio promotion for you. You heard? Download our app, Y'all Heard Radio. That's YAHHEARD Radio from your Google Play Store today. Y'all Heard Radio provides a commercial platform for independent artists. Tune in our live stream at www.yallheardradio.com and join our international listeners for commercial-free clean music in all genres. Have your music played among the best. Build your fan base, receive licensing and royalty opportunities. For promotion or more information, go to our Contact Us page at www.yallheardradio and create your login credentials for access to log in to sign up. For more information, call 904-900-5517. You heard? Hi, I'm Rachamah. Need office space, a business phone system, or a business address for your home-based, mobile, online, expanding, or downsizing business? Go to www.businessfront.space. You can reserve fully furnished private office or meeting space by the hour, utilities and Wi-Fi included. Reserve now at www.businessfront.space. Never miss your mail with our informed delivery service. No matter where you are in the world, sign up for a physical address today at www.businessfront.space.
Hi everybody, I'm Tahaka. Student loans, child support, credit cards, foreclosure debt, and much more are some of the problems facing my people. There's a right way and a wrong way to deal with these problems. Proper status in commerce does play a big role. However, we want to get rid of the so-called debt. Go to www.newdebtelimination.com. That's www.newdebtelimination.com. Let's get off the plantation. Let's not bog down in it. Let's get rid of it by getting rid of these debts. You got to get rid of the debt. If you're going to have a clean start, that's where to start. If you're opening a business, the first thing you want to do is get out of debt first. Once you get out of debt, now you can think about going forward and doing something different. www.newdebtelimination.com. Hi, I'm Tahaka. I have questions. What does it mean to be a creditor? What is a secured party? Just what does it mean, all rights reserved and without prejudice? Just what does it all mean? What is the law exactly? To know it all and to use it all, go to www.newdebtelimination.com. That's www.newdebtelimination.com. Get yourself together. Get out of debt now. Learn how to be a creditor and not a debtor. www.newdebtelimination.com. Call me directly, Tahaka Al Bey, 904-303-9061, before 7 p.m. Eastern Standard Time.
P.O. boxes are outdated, and digital mailboxes are in. Worry about missed or theft of mail or packages when you're not home? Want to know what's in your mailbox without having to get in your car and catch a ride to the post office? Do you have a need for an alternative address or phone number to use instead of your home address and personal phone number? What if you could get rid of the paper clutter by scanning and storing documents all in one place? Your mailbox address works like any street address. We take a picture of the mail and upload it to your account and notify you. You log in from any device and with one click tell us what you want us to do with each one. You'll love your digital mailbox at www.businessfront.space. You'll love your... Looking for a new business opportunity? Join Hemp Now Legal by sending an email to theconsciouscouch@gmail.com. Farmers are quitting tobacco and turning to hemp, and so should you. Join Hemp Now Legal by sending an email to theconsciouscouch@gmail.com. Hemp is the #1 superfood and healer, giving you protein, omega-3 fatty acids, magnesium, zinc, and fiber. Boost your metabolism, support weight loss, immune function, depression, and anxiety. Visit Hemp Now Legal by sending an email to theconsciouscouch@gmail.com.
Next level.
everyone. Hello, 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 and welcome back to Rachamah's Conscious Couch, presenting the Honorable Al Bey Esquire and affiliates. So we have a very special show for you today, specializing in the areas of corporate intelligence, consultants, and international affairs management in the normal day-to-day operations of business. And remember, all of our callers, to speak with the host, dial 1 from your dial pad. You may have to dial pound afterwards. I'm sure dial 1, and if 1 doesn't put you in queue, 1 and then the pound sign to speak to the host. You're going to dial 310-982-4184, 310-982-4184 for all of our listeners to get in queue to speak to the host. Just dial 1 from your dial pad. So, as usual, running through our commercials before we get started is something that I wanted to go over with you guys today, and to give you more information about the industry use of virtual offices and mailboxes. So, all of you that have the business addresses that you need for your businesses, home-based, small businesses, mobile, downsizing, and expanding businesses, we promote especially middle-class business growth. So we want for you to stay in business, and we want for you to expand your businesses, and we want for you to separate your businesses from your home life, and getting a virtual office is the best way for you to go about and achieve that. So you can go to businessfront.space. That's businessfront, FRONT.space. And you go to that website, and you can click on the physical address and get a business address for $9.99 a month. It'll come with electronic mail, so it doesn't matter where you are in the country. You will receive your mail notifications that you have mail, and you'll actually be able to see what mail is there without having to guess. And it's great for privacy, right from your app, and you just tell us what you want for us to do with the mail. Another thing is if you're a family, maybe you're someone that travels a lot, or you just, for privacy reasons, for private processes as well, we have a private mailbox that is on the Postmaster General side. You can get those as well, starting at $9.99 a month. I believe it's the one at $14.99 for like a family. You can get more than one or two recipients for $9.99 a month, same concept. You can contact us for more information at virtual office at businessfront.space, but make sure you go to the website. And for those that are in the Jacksonville area, in Jacksonville, Florida, we do have the hourly office rental and fully furnished environments for you. You can also access that on virtual by emailing us at virtualoffice@businessfront.space, or you can go to our website, businessfront.space, and you'll see where you can book meeting space and you can book private hour space, and we'll give you a free hour on us just for stopping through and trying us out. So today we're going to learn about who is the Honorable Al Bey and Associates. So far, just an overview about the Honorable Al Bey. He is part of the Federal Bar Association, Tribal Court Section, a member of the American Bar Association, a member of the American Judges Association, National Association of Tribal Court Judges, National Native American Bar Association Foundation, National Lawyers Guild in Los Angeles chapter member, take part of the Take Justice Back activist in Washington, a Washington, D.C. member, and the League of Indian Nations of North America and Canada, International Indigenous Affairs High Council, founding member of Diplomatic Agent, International Indian Treaty Council and UN certified, etc., the National Congress of American Indians in Washington, D.C., Herodotus College accredited professional mediator, fact-finding consultant, ACLU, American Civil Liberties Union, Strategic and Competitive Intelligence Professional, SCIP. So and also U.S. Press Association contributing member documentaries. There's also part of the U.S. Press Association.org members registry pro training affiliate program, CPR first aid certified, United States style Chief Judge Honorable Al Bey. So this is a long, long resume, and this is going to be a great, great, powerful interview. As you see, he is highly accredited, and so we're going to really indulge into some civil processes and some alternatives. So we're going to talk about alternative dispute resolution today, what is that, and some other legal options that are available out there for you. Welcome to the show, Honorable Al Bey. How are you doing?
I'm very well, thank you. Can you hear me clearly?
Yes, I hear you perfectly well, loud and clear. It's a pleasure to have you on the show today, especially with this long bio, but it's excellent. It's awesome. It's awesome.
No. Those are just the accolades of membership. I do nothing alone. All of my affiliations are based on just that, association, and, getting involved in the common core of our American civic system, specifically Native American civic system.
Now, even though I'm in Florida, you're in California, but we would agree that the law is the same everywhere. So no matter where we are, things that we're going to capitalize on today, we're going to speak about today, will give some clarity about the options that are available to everyone everywhere, correct?
You are correct. I do agree.
Okay, great. So ADR services, alternative dispute resolution services, seems to be one of the main things that you offer on your website, which is, what is your website? It is the Al Bey and affiliates.com, correct?
Attorney in Fact Assistance League.
Yes. AttorneyInFactAssistantLeague.com. Great. So tell us a little bit about Attorney in Fact Assistance League, what prompted its foundation, and what services the core foundation services that you offer there.
Okay. In that order, if you like. What prompted the creation of the Attorney in Fact Assistance League was the constant need for individual consultation in various issues of trust management, asset management, corporate affairs, individuals who were, incorporating for their own purposes but needed more direction, needed to implement board systems or even a protocol for how to run their company. That's where the inception of the Attorney in Fact Assistance League was born. What else did you ask me? I do apologize.
No, you're fine. I'm notorious for asking multiple questions. I wouldn't be me without it. What is the core services that you offer? From my understanding, outside of trust and asset management.
Yes, but see, asset management has its own certifications and functions, but we find ourselves in a position of business continuity. So let's say you come into a business concept now, we're assisting you in putting that concept into existence a decade from now, if not longer. And that is what we would consider future business value, future growth value. And so we specialize in some of that. Going back to ADR, alternative dispute resolution and mediation, my specialty is transformative mediation. I deal more in the elective field of ADR, wherein, individuals can broach the subject of some of the conflicts that they're going through, corporate or otherwise, and we can come up with customized or, solutions to some sort. I think a lot of times individuals just aren't taught the research methods necessary at law where you can find a solution. The law always has a solution of some sort, never the first time that someone has gone through a particular conflict. Would you agree?
I agree. I most definitely do agree. And we hear that term a lot, at law and in fact. So we hear something saying, okay, so attorney at law. That normally belongs to the Bar Association's bar card holding members. And then we hear the term attorney in fact. Could you go over the difference between those two with us?
So the specifics of attorney in fact is specifically an agent authorized to act for another party, corporation, or legal entity. And so the distinctions at law are attorney in fact are not solicitors. Those that represent the attorney in fact office are not normally solicitors or barristers of the court. They are not, necessarily officers of the court, but they are friends of the court. Attorneys, in fact, are friends of the court. So that's a good way to describe that. Attorneys at law have their own licenses in the respective states. They are members of the several bar associations, and they are governed accordingly. There are many instances where attorneys, in fact, do collaborate with attorneys at law in and out of court. So it is a functioning relationship that is it's just long-standing. It's nothing new at law, the position of attorney in fact, just so we're clear. Go ahead.
So the attorney at law are solicitors, and the attorney in fact is not solicitors. And we hear
not a barrister. Yeah, very good. Go ahead. Friends of the court. I'm going to push it for you.
Friends of the court a lot?
Yeah.
Okay.
Yeah. Because we don't come in under. Go ahead. It's administratively, there's nothing anyone can do to bar you from having someone qualified to come in and speak with or for you. Now, there are certain instances, I agree, but remember, I'm in the ADR section. So alternative dispute resolution does not bar you from having someone come in with or for you as an attorney in fact to represent your claim or to facilitate your management of a particular claim. No, there are no limitations there. In the courts of the several states, yes, there are limitations amongst representation without a bar attorney, and I would at no time, I don't even advocate that way, ask anyone to go before these courts without having a competent counsel. That's one of the largest reasons of my affiliations with the several that you mentioned, is because we always want to stand before the courts as clean and in order. We want to come before the courts in the best capacity as possible. Large portion of that is having good counsel. It's just the case that in most mediations, individuals do not have an attorney representing them in most mediation or alternative dispute resolution circumstances. So that's where the attorney in fact position does present itself. Does that better help for clarity?
It does, and I want to go into that just to touch bases real quick about the attorney in fact friends of the court and competent counsel. So, I do the 3 L's. I go in the courtroom, I do the look, listen, and learn, and I'll be there from start to finish. So from like 9 to maybe about 12 p.m. from time to time. And being a court observer, you'll see many people get in front of the judge and they're trying to fire their attorney, and the judge will let some take up a Feretta hearing and fire their attorney and then, represent themselves or present themselves, their case. And then others, they'll just ask, what is it that they have not done for you? And then at the end, the judge will say, well, I found that they've done something, so they're not ineffective. So they're having a hard time trying to fire an incompetent attorney. And the judge finds as if because they cannot articulate what their attorney did not do for them or did do to them, then they're not competent. So they go with the lesser, incompetent one, and usually it's the attorney that stays on the case. So how can someone get rid of an incompetent attorney on their case when the judge won't let them or the judge won't remove them?
So throughout the several states, there are many mechanisms at law. Most times the most formal position is to request a recusal of a judge based on whatever you consider the conflict of interest to be. There are administrative filings, but, like I'm saying, I want to make sure that I stand affirm. It is best to have competent counsel. If you need to find another attorney, try that. There are many courtroom and lobby attorneys that, are standing by waiting on someone to just offer them an opportunity to intervene. So, yes, there are a myriad of forms and documentation that one can use to recuse a judge based on conflict of interest. Where cited, it could be, broad-reaching, or it could be limited to the particular scope of the case. Does that help you?
A little. So basically, if the judge won't allow for this attorney to get off of your case, you would put in a recusal from the judge from off of the case. If all fails, from seeking alternative counsel through the people that you're saying are in the court on standby. They're usually, let's say if you're with the public defender's office and you have a public defender, then the next level you'll go to will be conflict counsel. Since if you can't afford a paid attorney.
You could, but I see it's just broad reaching. You understand, in criminal versus civil, there are just different levels of how the process works. So I don't want to intermingle all of them into one justification. That wouldn't be proper. In most criminal proceedings, if one is represented by public defender, there are just so many intricacies. I don't want to paint it as one particular brushstroke. I want us to be clear that in some instances there are many conflicts of interest, not just the attorney's abilities. There are sometimes the matter of them only getting 2 or 3 minutes to meet with you or communicate the merits of your case. So there are many different areas. I think the ACLU and the National Lawyers Guild, if I had to drop names, have very good resources for individuals to combat those particular conflicts at law or seeking justice. So please seek the resources of the NationalLawyersGuild.com or the American Civil Liberties Union, just for sake of clarity and education. Does that help you?
Okay, great. Yes, and I've always found that the Florida Bar rules of under, I believe it's Rule 4 on the client and attorney relationship is pretty good place to start with, at least trying to identify the way they understand to communicate, what you're not getting in that client-attorney relationship and what they're not doing that is afforded to you as a start. And
see, but the articulation,
so, yeah,
is very specific. That's what I'm drawn to. It's just, stay with what I like what you're citing. Florida's one place. Throughout the several states, I've come to understand that there are just many different mechanisms that are useful in advocating for the individual who may be unheard. So it's I like Florida. I like what you're citing, but throughout the several states, there are just many different mechanisms to move the court in a particular direction.
Great. Now, in talking about alternative dispute resolutions, whether it's civil or if it's criminal, we're so used to, especially if you're the defendant or you're the respondent, whether if it's civil and it's, let's say, or civil or criminal, and if it's the state coming at you or one of their department or agencies, we're so used to the end result is whatever they offer, whatever they lay out that is available. But you're saying that litigation is not the only option that you have. You have alternative dispute resolution, ADR services. Could you explain what ADR services is, the components of it, and we're going to further discuss some scenarios of how it can be used to resolve issues.
As always, I'm looking for my notes here, and if you'll just give me one breath count, I will have them in my hand. I do apologize. Okay. So, the area of evaluative public law mediation, ADR services, includes human resources, the Online dispute resolution as general concept is applicable to a vast range of disputes. The low-hanging fruit of the fully automated ODR, online dispute resolution, includes certain high-volume or low-value distributive e-commerce, eBay claims and legal disputes, traffic ticket disputes, appeals of property assessments, and things of that nature. As we understand it today, courts are also now increasingly operating online, both in e-filing and online referral to alternative dispute resolution services or ODR opportunities. So, from what I've shown you in the years that we've been acquainted, it has bloomed to evictions. It's bloomed to landlord-tenant disputes. There are just a host of different issues that just can't be weighed over in just the minutes that most court time gives you, and just need a little bit more of a sway or an angle, if you will. Does that help?
So the ADR services, instead of litigation, you can mediate your claim. Some of the things that you just listed were civil in nature, but these services can be applied to criminal in nature type of issues, correct?
It can be, and that's why I started by introducing it as evaluative public law mediation as well as alternative dispute resolution services. Evaluative public law mediation deals with the larger issues, what we would consider at law to be high-volume issues, and other legal disputes that just may not be underlined. That's where the evaluative public law mediation services would apply. And one needs to seek out an evaluative public law mediator wherever they can, if my office can't be of service.
Okay, and so I remember when we were talking one time before, we were talking about the ADR services in court cases, especially criminal ones, for example, or really high-level type of civil cases. Litigation is considered when they're pushing to go towards trial.
Okay.
And a plea agreement
and it's aggressive.
of
Litigation is aggressive. Let's be frank. Litigation is very aggressive. The tactics of litigation are they can be a catastrophe in some instances. I'm sorry, I don't mean any disrespect, but it's just the tactics that are used in most litigation are to tear down the opposition. And I find that mediation and evaluative public law mediation gives you an opportunity to advocate your claim, to research and fact find where there are merits to your claim, and to determine in more of a friendly or peaceful environment if there are any, merits whatsoever to the conflict in itself. We don't seek to solve the conflict so much as we seek to air out what the conflict is all about. You understand? The goal is for the individuals themselves to solve the conflict. And when you talk about tickets and other things, it's just about being responsible in essence. I've seen throughout the several states, Philadelphia and other places where they are, branching out to just give it over to, judicial officers who are dealing more in mediation or community justice type of situations. Everything doesn't have to be criminal. I do not want to branch off and say that, a murder case is eligible for mediation or evaluative mediation. Maybe it's not. I don't want to overreach that way. Go ahead.
Now, when you were talking about fact finding and finding merit to the claim, I know I personally have an issue with that term because we hear it from the state a lot when they talk about bringing a claim against you and saying that these are the facts, and you hear things where they say that there are no undisputed facts and these are the facts, but they're supposed to be allegations and presumptions. So how can they be facts and how can they state them to be facts if you're in dispute that they are true? I mean, where could you like define this whole term facts, and how do they stand with the position to even allege that they are facts without any, with the limited information that they were provided?
I understand. So if your question is based on law, then we're looking at Black's Law, anywhere from the 4th to the 10th edition, and you're describing facts as evidentiary evidence of truthful events or, writing. Normally facts are held to be what is law. Law is factual. Truth of law is supposed to be factual, held to be factual. So in your instance or in your example, I understand it to be what most people would consider to be just the interrogatories between parties, you see. And so these are disputable issues. What you spell out in affidavit or otherwise can be contested by another party. So, yes, what is factual to you and holds to be your truth may not be the truth of a particular situation, claim, or, legal scenario. So, that's what I'm saying, that ADR allows us to delve into the areas that most courts would like to, but, for constraints of time, just cannot. They're barred. They're barred from being able to do more. Have I helped you?
Well, the whole issue, even starting from the arrest, let's say if there's an arrest warrant that comes out, for example, and like you said, an affidavit, they all start with an affidavit from the officer, and they it's notarized and everything signed by a judge when they're getting ready to get the arrest warrant, and they say these are the facts. And then you go through this whole pretrial process, and these so-called facts, you're expecting that if I can prove that these facts are not indeed facts, and I can dispute them all, the question is that after you have disputed them all, why does the court still move forward? And it's a little why does this court still move forward?
So that comes down to standing. And so, I don't know how broad-reaching or how much time you have for this radio show. If you're willing to give me an additional 6 hours, we can go into. Yeah, well, we can go into legal standing, and a lot of that just boils down. I want us to be very clear that what you're reaching at, speaks to a broader audience than just mediation, but it does point to the fact that in a lot of instances, individuals may need to fine-tune or forensically investigate the charges that may be laid against them, and really get down to the brass tacks of what is a boilerplate conviction or allegation versus what is, suitable for a particular issue. See, a lot of instances in our communities of color is that what would be normally identified as a misdemeanor is automatically trumped up to a felony. Is that where you want me to go? You want me to sound more emotional along those lines? Because that's the reality of our No, it's just, I don't want to, I'm trying to give more of a diplomatic approach, but just, there are some very hard-pressed issues in our communities of color that point to the issue of, misdemeanors not being treated as misdemeanors. In most instances, misdemeanors could be mediated or evaluative mediated or arbitrated or some sort, but you're not. You're embarrassed before the court. Charges are trumped up to something more than what they ever should have been, and it's just an embarrassment to the justice system. There are many advocates out there who want to curtail that and come up with more solutions. I advocate along the lines, as I said, of the National Lawyers Guild or the American Civil Liberties Union, because there are many different entities out there who want to effectuate a more complete justice system. I hope that's where you want to go with this.
Well, that is the key. We do want to have more integrity in the judicial system because it is lacking integrity. We have an issue where cases are in court and are pushing towards litigation and shouldn't be there because there's an issue where They say, well, the judges decide the matter of law, and the jury decides, like the matter of questioning about who's right or wrong. So people feel as if I can go through this pretrial process and show them the position I came from, or to show them that, the things that they alleged as facts are now disputed and they're not, and there's no law that needs to be decided on, because now it's the issue of which side is believable, then we're getting into the one-sidedness, I feel, of the preponderance of the evidence and beyond a reasonable doubt, which are the bare minimum things that are needed just to initiate a case. Why can't it be the same thing that could dispel a case during the process to avoid it taking up taxpayers' dollars, moving forward into more time of tying up our court system and going through litigation, and then going to an incompetent jury that is not educated on law whatsoever to determine, which one sounds better. And, these people, they have these titles and they have this credibility, so anything that comes out their mouth is more believable than what the other position proposes. That is my argument that frustrates me with the inequality that is in our system. And so the question is in order to restore integrity into our judicial processes once again, if understanding, what is that, what is beyond a reasonable doubt, how to get rid of a case, improving your case at the beginning to avoid litigation, how is that obtainable with the injustices and the inequality in our judicial system? What are some of your pointers on how to maneuver through this type of system where all of the odds you just mentioned that are stacked against people of color?
I believe it's very important to stay well studied at law, politics, and the changes of law and politics. The ACLU teaches that we should be well acquainted with the district attorneys in our respective counties, states, and local governments, and be able to, make them aware that, we are studied as their constituents, et cetera. You have to remember that the jury system is based on a jury of our peers, however that comes together. You understand? And so the common man is put on a pedestal to deliberate justice in a lot of instances, and you only get a crash course at law or what the prosecutor or others will, describe as their allegations in a particular claim, So we have got to stay well studied. Individuals have got to, get back into the libraries, et cetera, and start keeping themselves abreast of what the changes at law are, abroad, just abroad. There are some really wonderful changes that are taking place at law that are starting to point to the fact that the people are listening. They're paying attention. They want to give back, more than a jail sentence in a lot of instances. They want to figure out a way to intervene. So that's what my opinion is on those particular issues. In the years that I've had the pleasure of being of service to others, and throughout the several states in the tribal circuit, I better understand that, it just takes a heart of compassion, empathy, and compulsion to want to be of service, not to hurt, not to harm, not to hinder. Handing someone a jail sentence of anything more than 5 years for certain crimes is just broad reaching. Really it is. Really it is. And if you're sending an impact statement to the general public not to commit the crime again, then, there's a double argument there, So, yeah, how far would you like me to go?
Now, I have read in some studies you made a great point there about those impact statements that are made to the public not to commit crimes. I've read that they knowingly, willing, and intentionally will commit implicit biasness against people, as well as subject people to sentencing disparities, and even take a good chunk and purposely sentence them when they know that they're innocent to be that impact statement. They'll sacrifice those people to be that impact statement to others to make an example out of them, not to oppose them, as well as not to commit crimes. And so here, at least in my area, people are at this heartfelt feeling of these people do what they want to do. They don't honor the laws that they are supposed to enforce. They don't honor the laws that govern them. So, do you have that issue? Is that something that you hear even in your areas and abroad through Al Bey Esquire affiliates?
It does come up. Yes, there are varying uniformities of justice across the board. A lot of individuals who study law, constitutional or otherwise, kind of put the map of the United States on a grid. And so, you have middle sections between Washington State, Montana, down to New Mexico and, California that have their own code of justice. You have kind of North Dakota, mid-country, South Dakota, and, Nebraska and Kansas and Oklahoma. I'd like to say Texas can or should be a part of that sometimes. Then you have other parts that are, New York and North Carolina in the South and sort of how they do things. So you have, this broad-reaching effect of, on certain coasts, facts are weighed over differently. Individuals weigh over facts based on what the interpretation of the law is only, you see. And so when we look at that as, a grid map or something laid out as a pie, you're able to say, okay, depending upon what your jurisdiction is or what the subject matter jurisdiction is or what state your claim is, you will or will not fall into the understanding of the original Constitution. You will or will not fall into the, merits of due diligence and some of the other, points of law that are just necessary. A lot of times, like I'm saying, there are boilerplate circumstances at law that allow people to push documents that hadn't been, served that way in 10 or 15 years, but no one's the wiser, not even the jury. You understand what I'm saying?
Yes. We're going to take a call from a caller. A caller has raised their hand and have a question, and when we return from this question, we're going to go more into law, government, and talk about the tribal circuit as well when we return from this caller. Caller ending 7188, you're on the air. Caller ending 7188, you're on the air. Do you have a question for Honorable Al Bey Esquire?
No, I have conversation, not much of a question, because, in America, there's two types of justice. And for me, I don't understand why the tenth of the African American community don't understand that or try to educate our community concerning that issue, the law. And for us being we've been here longer than 600 years in what they call America. But my concern is we should know this stuff by now, that there's two laws in this country. And until we respect that law, the difference, I'm talking only about the difference, then we must understand that if we do not get civic engaged, do we not invest into our own community and do for self, the law going to always be against us. That's my comment.
That was a great comment. I'm going to put you on hold just for one moment while we can get a reply back from the Honorable Al Bey. Hold on one moment, please.
I'm here. I stand in agreement. I'm not critical in any way. I mean, my whole point is to be diplomatic or phlegmatic when giving such a broad-reaching audience content and information. But, yes, there are some very evident cases in point where our people have been offered a lower standard of justice. And the caller and gentleman is 1,000% correct. Absolutely.
I agree as well. It is an issue, the fact that, like you said, we've been in this country long enough. We should know, even though we know that the hands, legislatively, that they're always writing, interpreting, and rewriting laws, and we have to stay abreast. And it has not education as far as literacy has been a focus for our people, but economics has taken an even bigger stance. And so trying to deal with law on top of it, make it a precedent, has another issue that has just been laid in the background because we leave it in the hands, not that we leave it in the hands of attorneys, but, like we were talking about earlier before when we were talking about attorney at law, the difference between attorney at fact and being a friend of a court. And it seems that people are rising to the point where they're reading and they're interpreting and they're even taking up some classes. They may not have a bar card, but they're wanting to stand up for or speak so that they could alleviate the language barrier or the legalese interpretation indifference or disability by communicating for someone to the court on behalf of someone in a way that the bar card holding attorneys can't, and the courts are not allowing it. And so would you say that these people that are studying and showing themselves approved, would you say that, is there a way for them to have someone, because the Constitution says we can have counsel of our choice. So why do we have to choose someone that is a bar card?
Yeah, but it really boils down to right to practice. And throughout the several states, the right to practice is trade in commerce. So when you're coming down to common law and how most things are weighed out at common law, yes, there are constitutional exemptions, privileges, and protections that are afforded to certain individuals who will study to show themselves approved. But, at a large value there, we're taught that the justice system is right on its face. And in a lot of instances, those that know law, practice law, or are scholared in it know that that's not always the case. I hope that speaks to the audience and kind of the broad, thought there.
Well, if right to practice is a right for trade, it's part of trade, which is part in trading. There's some type of bartering system, some kind of exchange going on there, and it's part of solicitation. But if you have someone that is doing it for free because they may be an advocate or because they have an intricate relationship with whoever is going through something in court, and they just want to be a legalese interpreter for this person, not to be on equal footing as an attorney, but just explain some things to the court in a way that a bar card attorney is prohibited from doing or saying, then those exemptions that are available that you mentioned for a friend of a court, is that something that is appropriate to access those exemptions by them putting the court on notice? Because some instances I hear people just show up. So is it the problem with the court because these people just show up and say, I'm a friend of a court, I'm going to speak, or is part of accessing this exemption is putting the court on notice in some form or fashion?
yes, there are procedures throughout the several states and the several courts, et cetera, that would allow one to give advance notice or, identify themselves as appearing in special circumstances. Normally, a durable power of attorney has its own kind of distinctions that if an attorney at law is necessary, then, that power can be substituted. But the position of advocacy under the said durable power of attorney, for example, would stand. And so you wouldn't be muted before the court. You would actually be respected as a participant in whatever the claim is, not necessarily the litigant himself, but a participant, an accepted participant. But we're talking about the several states. I don't want us to mix this into one state. What doesn't fly in Florida may be perfectly fine in Michigan. You understand? Or New Mexico or Utah. What is totally unacceptable in California may be fine in Oregon or Arizona. You see? So it just really depends.
Right.
Yeah.
I'm finding that the courts are not taking power of attorneys anymore. Certain divisions of them, let's say if you go into the records department and you may have someone you have a power of attorney over, and this person may be a pro se litigant or something, and they may be incarcerated, and you want to get copies of their court record to send to them unredacted, and then they'll say, we don't take power of attorneys in order for you to act on behalf of this person. So my question is it, in your opinion, legal or unlawful for them to say that the courts in different departments within the courts to say that they don't take power of attorneys? It means nothing to them?
Yeah, I want us to be very clear throughout the several states. There are instances where the procedures of the court are not followed, where the rules of the court are not followed, and we find that to be unacceptable. So I urge you to, seek your local, advocate of some sort. I'm a card-carrying member of the ACLU, but I've seen, really wonderful works done through their office. I participate in activities with the National Lawyers Guild, and I've seen, advocates really make headway with exposing those particular conflicts in the system. So, just reach out, please. Let's allow the community of others that are out there by affiliation and association to help.
But I understand what you're saying. So basically you're saying because in the several states there are different rules of the court, different applications of the law, just to be stayed abreast to what they're following to see if or not the people within that industry, their employees, are competent themselves on what the rules are. Because there's a lot of people, I find it all the time, they just show up for a 9 to 5. So we have to remember the people that work, behind the counters in these places. They're, 9 to 5 there. They're just receiving a task and a paycheck in return, and they don't want to do or know no more other than, whatever paper pushing or whatever the people say they need to do to keep their job. But you do have to, learn their policies and their rules and then escalate it above them if or not they are acting outside of what those protocols are. So I do get that 100%. Now, you do something called forensic discovery. Could you explain to the people what forensic discovery is and how that will help them? Go ahead.
Oh, very good. And I do apologize. I want to make sure that I am listening very keenly to your wonderful voice. I don't ever want to speak over you. Let me see. Yes, evaluative mediation under public law can dissect certain elements of a particular case, civil or otherwise, into a fact-finding mission, wherein I would describe it as forensic investigation or forensic discovery. Legal discovery in itself is forensic. because you're going to dissect all of the elements of a particular claim down to its brass tack. Where does jurisdiction stem from? Are these the actual litigants? Is there an actual claim here? Is this a frivolous lawsuit? I mean, there are lots of different things to weigh over there. So that would be my description by profession of how evaluative mediation helps with the forensic discovery process. Does that help you?
Now, what comes along with this forensic discovery? Does it break, I find that the problem with a lot of people is not knowing the rules of procedure and knowing the laws that go along with what they're trying to articulate. And that's the problem, is the articulation. They know what they want to say, but these people want for you, in the court system, they want for you to say according or pursuant to rules such and so, such and so. And then the laziness as well, too, because then you can articulate and you expect for them to say, oh, you're talking about rule such and so, and just match it together. And instead they're dumbfounded. And it's like, I don't know what you're saying. Like it's I call it Rumpelstiltskin. Like you have to know the exact name, and you have to match everything together for you, and you got to do the word for them. And so the question is that we can identify the wrong that has happened to us, but we don't know if it qualifies under a certain law or rule, because we have people in the system that says, oh, well, you need to go read this pamphlet. Okay, so we read the pamphlet. Then when you do what the pamphlet say do, then they say, oh, you misinterpreted it. You're applying it wrong. Well, if I contacted you the first time, and I'm like halfway venting because there was an issue with lawyers, and when you contact the American bar, they told you about these pamphlets that are, or any bar association, they tell you they have these pamphlets that are available on their site, and when you look through these sites, and it tells you what your rights are and what to do, and when you exercise those, then the excuse for not enforcing what it says that it protects or governs, they say, well, you misapplied this procedure to it, or you interpreted the meaning wrong. Well, but when I was calling you to interpret it, you told me everything I need is right here to go and do it. So I think that this is just an issue for them not to get involved in war with each other and govern each other. Is it something other than what I see it is?
No, I guess you're correct. What would I like to say on that particular issue? There are many conflicts in state procedures. What we find in our judicial system is that the idea is that the rules of court are there to assist us in better understanding how to apply justice. The interpretation of law in itself is open to each individual judge or jurist. So, there you go with that one. It's always open to opinion. Most judges and judicial officers issue opinions, and those opinions can be contradictory, and they are, stricken down by higher court. So, there's a process there. There really is a process there, But your example rings true.
So when you do your forensic discovery, are you applying or the end product that they'll receive? Because, from my understanding, from my readings, you conduct these forensic discoveries. They're available for people who have different litigations going on. Are they getting the laws or the codes that go along with the discovery? What can they expect in the discovery to tie everything on in, and then once they receive it, what they do with it?
So if I understand the question correctly, you're asking what is the purpose of legal discovery and what substance can be found in its implementation?
Well, what I was asking was, once you conduct the forensic discovery, are there any laws or codes that comes along with it that they can use to further the closure of their case, and where would it go? What did they do once they receive the discovery back from you? What do they do with it?
Well, it's fact. It holds itself as fact. Whatever they receive back from my office or the various elective mediation offices is fact. We are neutral. I'm not a party to the case. If I investigate anything, I'm investigating for its merit or for its substantive law purpose or whatever, But, that's my position. I want to understand how it all came to be. To say I'm very scientific in the application of said process, but, we all have our own forte or style, And so my style is to give you basically an intelligence report that identifies what you see before you, what the options are, what the legal remedies are. All the way broad-reaching as being able to point you in the direction of Google Scholar, and give you applications of law, that are free, nothing that you cannot find, But we're trying to get to the point where law is not so codified that you can't just go look it up. You understand where I'm coming from?
Right, that makes sense. And it's just that the participation of the people in their legal processes have to be easier than the technical terms that are used. It just looks so technical. It just sounds so technical. And it has to be more simplified than what it really is. And having services like alternative dispute resolutions and forensic discovery is an important piece of that, in my opinion, because it does break down the technical part of a case to where someone can understand. Because if you're, I know I've experienced it, and I know our callers can relate to it. When you one of the arguments when people are dealing with attorneys that they say there's no communication there. They just want for them to just dump paperwork on the table, give them a little excuse, and they don't want for them to participate in the process and just move out of their way. And when the end product comes, it's no product at all because they're not familiar with any facts in their case. It seems like they, and then when you do try to, touch bases with them, they give you excuses about they're busy on somebody else's case that they were working on, whether if it was someone going to trial or a death penalty case, and then when they get around to your case, they don't know who's doing who and who did what when. And then they go before court, and you really haven't done anything. And so people are, really tired. The community is really, really tired of going through all of that. So being able to have some alternatives outside of what is available is what's happening. It's just that the people in the court, the attorneys and all of the actors, they're there every day. So the civil procedural part of it is just traditional, and it's just automated to them. And I think that the citizens or the community that are taking the time to read, that they know the law, but they're not in the courtroom every day, so they're not abreast with the procedural part of it. And I think that maybe a higher percent of that, but I'll just say 90% or the majority of court proceedings to me seems to be more procedural in nature than any application of the law. Where do you stand as far as my observation on that? Would you agree with that? And if you do or don't, could you give a reason as to why it is structured that way? Because it's surely breaching the public trust and is creating issues within the court system.
Your observation is very coherent, and I do understand the passion that you have for that particular issue. In my personal opinion and in my observations throughout the several states, yes, there is a disparagement in the confidence of the judicial system sometimes. Individuals don't necessarily always feel like they're going to get the best results. As far as preparation is concerned, yes, I mean, you know, we want to do our best to point individuals in the right way. The practice of law, as I said, it's commercial. It's based under commerce. And so with that understanding, there are some really phenomenal lawyers out there who can give you what you're probably looking for, but it's trial and error. You know, there is no cookie-cutter approach to law. Anyone that treats it that way probably, you know, should go into baking or something, but not law. That's my opinion.
We have our callers raising their hand, caller number 7188. Do you have a question or comment for us?
Absolutely. I agree exactly what he was speaking of a few seconds ago. But what I'm concerned about when it comes to my community, African American community, is the fact that we don't understand the spirit of law, and it deals with a lot of bias. Understanding, well, we could talk the rest of the day about the different bias, but when it comes to the African American community, there's very few that's civic and social engaged in the running of their community and to make a difference when it comes to understanding what takes place when it comes to law and economics. You know, in closing, I'd just like to say here, until we understand the spirit of the law, as far as I'm concerned, we will not be able to move forward as a nation. I'm talking about the African American community. Thank you.
Honorable Al Bey?
Yeah, you won't get any qualms with me. I mean, in fact, I got chills just from hearing his statement. It is true. The spirit of the law be held and upheld, you see? And it's just too important that we, you know, my motivation personally is to encourage all to just show themselves approved and study. Study, study, study. There's no harm in studying. There's no harm in staying abreast. There's no harm in, you know, researching what you thought it was and discovering what the truth of a matter is. There's nothing wrong with that. And also being able to say that anytime you are alleged or accused of anything, regardless of what it is, be kind enough to yourself to investigate the merits of the allegation. You know, don't allow someone to, in essence, plea bargain you into incriminating yourself, if that speaks volumes to your audience.
Well, now that is the issue. That is the issue that's played in our community all the time. So, you know, there's even a scripture in the Bible that says, you know, woe to those attorneys. You know, I'm paraphrasing, that they do not touch they don't even touch your problems. And they get all these benefits. So I totally paraphrase that, but those know which one that I'm pointing out. And the problem is that, oh, you know, if you were innocent, if you're innocent, I don't care. I wouldn't take a plea. But you know what happens when you are a person of color and you already have a lot of it's an economic advantage for you to be in the system because they're paid housing you, they'll get paid more for a longer term. So it's financially lucrative to have you in the system, and then you're threatened, armed, you're standing in this room through all these procedures and shackles, you know, with people with guns on their hips and everything, and people in front of you that are very intimidating because they have, like, the power over your life. And then they're threatening you, saying, you know, if you go to trial, we're going and you lose, we're going to throw the book at you. That's what they say, because you wasted the court's time. How can you waste the court's time with exercising your constitutional right to defend yourself. And you may be faced with ineffective assistance of counsel. You may be affected by an inept judge. You may be affected by color of law abuses that are happening to you. Something that I term, that I'm going to push to go into some legal dictionary somewhere, it's called intellectual discrimination. The fact that you are studied up, or you get studied up and you learn the law, and you enforce it, or you utilize it, they're now offended. Like, who are you to tell me, what my job or whatever it is? Look where I am. Look where you are. So how would, if you are given a plea, and that plea gives you the opportunity to retreat and fight another day versus facing the odds of getting the book thrown at you out of retaliation for fighting for your rights, and then what happens to you? You fight for it, and the same attorney that talked you into fighting for it, they wash their hands out of it, and they say, oh, if you have a problem with it, you have to appeal to the district court. Oh, by the way, I can't help you in district court because, I only practice in circuit civil. You have to have a different attorney to help you there. You kind of see that crazy tornado, downward style cyclone that you're going through. It's crazy. It's like they're wiping your hands. They're wiping their hands of you to get rid of you, wiping your hands out of you to help you. So how do you speak to people that is under that type of frustration, that don't even realize that that's what's going to happen to them if they don't win?
Those are the checks and balances of our
position?
Those are the checks and balances of our judicial system. And so, there are many instances where a lower court makes an error, and you would need the wherewithal of a higher court, district court, or, state court or otherwise to intervene, So we want to be very, positive about the idea that, this American justice system, while it may have been, formulated by historical bad practices, we understand that in today's advancement of justice, we're trying to make headway in laying down a foundation for the future of the American society. Everything, some of what you mix in there, it's criminal and otherwise, but, there are many really noteworthy cases that have taken place over the past several years that have spoken to the rights of the people and assisting the general public with better understanding the court system and what the function of the court is. It's not always adversarial. In all honesty, it's not. Now, yes, you do go to court when there's a conflict, but there are other instances also, you see, just to set the record straight. So that's my opinion. That's all we have in our American society is our judicial system. Outside of that, we go back into the dark ages, if you will. So we got to do something to support and encourage.
You mentioned we have an adversarial system. Could you explain for some of our callers what an adversarial system is? I know a lot of people hear the terms, but no one really.
Yeah, well, that's the particular reason why I chose to go into mediation, is because I understood that under the auspices of the judicial system, there are limitations. There are just many limitations. Some of my greatest colleagues and affiliates, throughout the several states have shared that, I can point you in the direction of resources, but I can't make you drink. You understand? It's like leading someone to water and watching them just stare at it. No matter what you want to do, if you're not wanting to be changed by the law, then you're going to be wanting to destroy it. You tell me what your motivation is. You know, we got to find a way of being able to lay a more finite tradition of justice. Now, there are many different applications, though, seriously. You know, there are peace courts. There are many different applications, and I've seen it throughout the several states. So, you know, it's just a matter of people coming together to participate. Civism and the process of civism is based in the people, realistically. Oh, wait a minute. And I apologize to your audience. Yes, I do have moments where I'm trying to keep track of where I'm at. Let me see. What was the term you wanted me to define?
Adversarial. You say that we have an adversarial system, and defining for our
the adversarial.
What is the adversarial system?
Thank you. Thank you very much.
Yes.
And I apologize to your audience that I lost my train of thought for a moment. The adversarial system in our judicial system is just that. Where we understand that judges are supposed to be the referees or the neutrals in court, a lot of instances and a lot of times they're pressed and hard-pressed by the statistics of the municipality, you see? And so the idea of being neutral is not so easy when you've got a quota to fill. Maybe not necessarily the prisons, but you need to make an impact statement, as you said, you know? So somewhere in there, we've got to figure out a way to move away from that. And some states are. I feel like, you know, when you start moving traffic tickets and things like that out of the criminal court system, you start giving people a better interpretation of what the courts are for. You understand?
Yes, most definitely. Now, we have a very engaged caller. We want for all of our callers to also know that if you want to dial in to speak to the host or our guest, you can dial 1 from your keypad. It's either 1 or 1 pound. And you can get in queue to speak to the host and to speak to our caller, which is the Honorable Al Bey and Al Bey Esquire and Affiliates. And we're going to, give you the calling number for those who are listening and need the number to call in. It's 310-982-4184. Again, 310-982-4184, and dial 1 from your dial pad in order to dial in. Caller 7188, you're on the air. Do you have another comment or a question?
Oh, I keep plenty of comments. My name is Stanley Scott. I'm with the African American Economic Recovery Think Tank. Yes, which you are a part of. Yes, I mean,
yes.
For me, it's always about education, and I'm talking about applied education. A lot of people are not familiar with the same as when it comes to knowledge, applied knowledge. We are not involved civilly in our community, and I mean when it comes to education about the law. It doesn't make a difference what part of the world you're in, and I've been in many countries. You have to learn the law, and we have to invest in that. And that means getting off Facebook or getting on Facebook and learning about the law, at least about common law, the law that you have to deal with every day. And once we get to the point of realizing the power of that, a lot of things that take place in our community won't happen. And that's my main comment there. Thank you.
Now, that is a very good question. Honorable Al Bey, common law. So, to me, when you say common law, I think of that as being the law of the land, with just the natural law, in which the people, when we engage with each other, to me, it's, common law is common sense, and it's law before all of, the ordinances and municipal codes and statutes and whatnot was created. But then we have, this other law, which is public law. So where are we right now? Because, a lot of people are starting to try to enforce common law into public law. Tell me where is this fit? Where is this puzzle fitting? Or is this puzzle not fitting? Is the one just bumping one out of the way or the other just warring against each other. Where are we now? Common law versus public law.
So what I have here is the American common law, law that is derived from judicial decisions instead of from statutes. Early American common law was taken from English common law. Some of the examples, obviously you know that I'm in the tribal circuit, are examples of Seminole tribe of Florida versus Florida, and that goes back to like 1996. Again, I'm in the tribal circuit, so most of my examples outside of alternative dispute resolution will deal with tribal and dealing with our Native American communities. But if that's what you're pointing to, then that would be the understanding that I have. Common law, law that is derived from judicial decisions instead of from statutes. Do we have a common understanding on that?
Yes. Yes.
Okay.
Now, where are we as far as with that definition that you gave? You know, they seem to be warring against each other. It's like back in the day when the Civil War was going on, we had the red coats versus the blue coats, and you know, the whole civil unrest type of thing going on to prevent tyranny, to prevent the treason of the public officials that we had held accountable over government. But now it seems the citizens are enforcing more. This is my common law right, and these public codes and, you know, things of this nature are a violation of the Constitution. So when you say common law to me, you're saying Constitution. But then statutory law is what everyone is being brought into the court, rather if it's criminal or civic, it's all statutory. And then so now the community is trying to enforce that definition of common law into the public courts, into public law, and everyone's complaining about these violations that are occurring. So why isn't common law being effective against statutory law in when dealing with public law?
In my opinion, it is understood that common law derives from the movements or actions of the several states and the common consensus of the several states court under their magistracies, and that, you know, stems from state high courts all the way down to their lowest county courts and city courts. Okay, so you have a general consensus that is derived from those opinions, public or otherwise. The understanding of public law, as we understand it broadly, is that which is ordained and established by Congress as a kind of operation amongst the several states. So it falls back on federal law, which is supposed to, you know, instruct the states in the most common way to go. But if we all stand in agreement to that, then, you know, we go into understanding common law to be common law is law developed by judges, courts, and similar tribunals, stated in decisions that nominally decide individual cases, but that in addition have precedential effect on future cases. So if we stand with that understanding, if you want me to read it again, I'll do it again. Common law, also known as case law or precedent, is law developed by judges, courts, and similar tribunals, stated in decisions that nominally decide individual cases, but that in addition have precedential effect on future cases. So if we're standing with that understanding abroad throughout the several states and the like, that is where we stand now, where public opinion in some instances can skew law or the courts or judges into a particular opinion or decision. You see?
Okay, I see. So with your experience in the tribal courts that you were mentioning before, because there are a lot of people that are coming to the realization of knowing thyself and, you know, doing everything from Ancestry.com, and they're getting the DNA done, and they're finding that they are of some type of native ancestry, and they're trying to use that to further enforce their common law, their natural rights, their human rights, into some of these issues that involve no injury to persons or property, no breach of contract when they're brought into the court. Is there a place for these people? Well, these people say, actually, and when I say these people, I mean these people that are getting the DNAs done, and they were maybe calling one of the bywords, because that's exactly what it is. If you're, black, and then you're halfway black and halfway African American right now. 20 years before that, you were halfway African American, halfway black. 20 years before that, you were colored. 20 years before that, you were Negro. And 20 years before that, you know what you were. So along these bywords where we are now, with them getting their DNA, finding that they are from tribal ancestry, they're saying, when I'm brought into the court, there's no place for me in this court. I'm not under your jurisdiction. So where should they go to handle their issues? Some of them say, I need to go take my case to the federal level, and I just need to just change jurisdictions and remove my case from out of this court circuit because you're not going to hear it lawfully anyways, and I don't have any business in this court. So where should they really be taking their case? Should they really be in federal court if they're of Native ancestry? That's my first question.
You know what? Now, you got me wanting to name drop again, and that's just how it goes, I guess. For those instances, I am almost captivated by the opportunity for our people to join the League of Indian Nations of North America and Canada, LINA.ca.com, LINA, LINNA, League of Indian Nations of North America and Canada. Please, people, let's submit your applications. Let's get our record perfected, and do our best to, start correcting the tradition of the League of Indian Nations amongst the several nations, because we can put this family tree together, but we need your help. We need your record. We need to be able to know who you are. The roles here all identify the names, but our descendants are plenty and very far and few between, So, yes, the League of Indian Nations of North America and Canada. I'd like to give a shout-out to the presiding chief, Patrick Sarazian, standing chief and head chief here in North America, Chief Akil Ali.
Now, the people who are getting their DNA and everything done that says that they're of Indian blood, you're saying, so is there a place for them in federal court? And is it true that they have no place in these lower tribunals?
Okay. You could do that. I mean, but it's required of you to actually be a member of a particular tribe, enrolled, and to be able to stand on the Constitution or the exemptions that tribe has with the federal government. It can be done, but you must be an enrolled Indian in a particular tribe.
Now, we have, there are some roles that I'm familiar with, like I believe Dow roles is one of them, that's on the Federal Bureau, the Interior Federal Bureau, something like that, of Indian Nation, something like that. But there's a Interior Department under the Federal Bureau for Indian Affairs. That's what it is. And so this League of Indian Nations of North America and Canada, this is recognized by the federal government, like the Dow Rows?
Yes. Yes.
Okay, and just to name a few, what are the name of some of the nations that are up under this league?
So broad-reaching, the League of Indian Nations has specialized for over 50 years in the unification of the several First Nations, as well as the 5 civilized tribes, and those unnamed and unrepresented, underrepresented nations throughout the several states. And so, the idea here is that for those who hold themselves out as individual Indians, there is an opportunity of enrollment with the League of Indian Nations to become a card-carrying member and to facilitate the completion of a data registry or record bank in Canada under the North American agreements and treaties and other things that would now unify the League of Indian Nations as it was originally formed and understood. Does that help you?
Well, then my next question is those that once they enroll here and it has a constitution, it's federally recognized, then from my understanding, just with the ones that are under DIROS, they have their own government, they have their own judicial system where just like you go in front of the court and they say if you are, I may be saying the term wrong, but you know what I'm saying, the judges say, if you commit this crime and you plead to it, you can be deported if you're not a citizen. I think that's what they say to everyone. And so with going up under these under one of these nations, I know some people that are extradited out of the United States system, and their case is being heard by their own peers, like really a jury of your own peers, of their own nation, of their own people. Would they have the same effect where they'll be able to reach out to the League of Nations, especially after getting a forensic discovery and investigating the facts and merits of the claim of the case, and have for their case to be transferred from out of this jurisdiction into that one? Is that what one of the purposes are for this league about it can help people?
The League of Indian Nations, in my opinion, is a way of assisting the individual Indian in making sure that they are at least enrolled or a card-carrying member of a league. And if we understand the legal definition of league is a protection agency or entity, that's our function as the League of Indian Nations, as I am a card-carrying member. And so that's kind of where my mindset is. First, get yourself enrolled, get your records in order, make sure that before you go before a federal court or otherwise that you have all of your necessary records that identify you as indigenous appropriately. Now, we can talk about historics and all the rest of that, but until you do it appropriately, it's just a mystery.
And since we're on this subject really quickly, I know that there was a lot of hoopla at one time surrounding around the Yamasee tribe, and there's another name that is used as well, but it derives from out of I think Louisiana, and the whole hoopla was over the Louisiana Purchase. In a family that it was a queen or a princess or something like that passed away not too long ago, and the son was supposed to have taken it over, and then there was some question if or not they were really federally recognized or not. Would that be any affiliation? Would that league have any affiliation with that one? Do you know which one I'm talking about out of Louisiana?
I'm familiar. And I would like to say that the League of Indian Nations has been in existence for 50 years. They were already in existence in Canada and here in North America. Despite the legal standing of certain tribes, membership in the League of Indian Nations is an individual pursuit. So the two shouldn't be mixed. The League of Indian Nations is its own independent entity. So any individual tribe that may or may not have obtained their federal recognition by historics or the like, that is its own argument, and they may need to seek competent counsel to get themselves where they need to be. But a lot of tribes that have come together under certain headings, names, and the like have obtained federal jurisdiction with less record than what certain individuals that you just spoke of may have available. So that's just an example. I'm just pointing.
Okay, great. Now, another thing that I wanted to discuss with you about was one of the services that you provide, or at least one of the things that you state that are important that people have access to is called a smart contract. So it's supposed to be some type of computer protocol that is intended to digitally facilitate, verify, or enforce the negotiation or performance of a contract, and that it allows it to happen without third parties. Could you collaborate that? Third party meaning it's between you and the other person and not an attorney or a judge or something like that. Could you elaborate more about smart contracts? Or is it just and why is it called smart contract?
Very good. Thank you for the question. So I'm along the lines of, utilizing technology for forms and completing certain tasks, especially in corporate America. We find ourselves tasked with creating our own management agreements, employment agreements, human resources agreements, all the way down to vendor services. And so you have, certain companies like LegalZoom or Rocket Lawyer that allow you to create certain documents of that nature under the assistance of an attorney if you need, but they interview you by populating the fields with questions, ready-made questions. You understand? And so the idea with that is, if you get used to using that type of technology, you find yourself being able to deliver the terms, the contract, and the opportunity for signature and the like without ever really coming face to face. And if it is at any time necessary to deliberate or arbitrate, mediate, or litigate even the merits of that particular contract, in most instances, an attorney was provided or assisted in the creation of the document. You see what I mean? So it's a smarter way of approaching some of the common, everyday contractual agreements that are out there. I mean, all the way down to your cleaning lady or your gardener. You have a way of being able to effectuate a standing legal document that will hold up in court if questioned, but there is a binding agreement there and present that was done online and with the assistance of current technology. Does that help?
Well, now, how can you utilize ADR services in, let's say, parenting issues and small claim issues when you have the other party that just does not want to cooperate? They're just belligerent or they're just really aggressive and it's like their way or the highway. How can you utilize ADR services for someone that doesn't want to participate? Doesn't it have to have, participation on both sides for a willingness to come to a resolution outside of litigation in order for it to work? Or is there some other way around it?
One cannot force another thing in mediation. It has to be voluntary. And there are many different styles of mediation, some that just make the environment a little more neutral, sometimes giving the other party the position of control, even though, there was compromise necessary to come to the table in caucus, So, no, you can't force anyone to mediate if they don't want to mediate. I mean, parties have to be willing to come to the table. And if that is the first meeting ground, then that's what we start with, that's there's no way to force it. I have experience as well as confidence in family mediation processes, which can intervene or lay out a roadmap for future custody agreements and things of that nature. But all parties have to be willing to participate, at least initially.
So if it takes both parties to mediate, and we know that mediation is something where, correct me if I'm wrong, a party stands in place to help each party come to a conclusion, but they're not making a decision for them. They're just letting them know all the options that are available to them out there, correct?
Yes. And in some instances, if there are adversarial parties or, disagreeable parties, yes, we can put you in separate rooms and make sure that you meet, in separate areas or whatever. But we can still act as a referee or a neutral to the particular issue, yes.
Now, so they can't force each other to mediate, but they force you into litigating. And, there's supposed to be something under the Constitution as well that says that the citizens are the bosses. They're the ones who make the laws. So the citizens are the bosses. They're the ones who make the laws. And any time that they feel as if a law is not serving its purpose and they can do away with that law, how do you make that happen? Is that something that has to go through a voting process that the majority of the people have to agree to in order to abolish that law, or does it mean that even people in their individual capacity can, just as being a contributor to those laws and powers that are given to public officials, that if that law is self-serving, then and they feel as if it is of no effect, then they don't have to follow it or let it govern them any longer, since the law is only enforced upon the governed, and which is supposed to be voluntarily, with them giving up certain constitutional rights in order to participate in this common law type of form of government that we have going on. But if you say, okay, well, I no longer want to give up any of my natural rights in exchange for this common law of protection from you, because you're the one who's attacking me, not the community in which I invested and entrusted these powers to you for. So, I don't want to participate in, this doesn't apply to me or that doesn't apply to me. Do we have the right to do that? Even though it says it on paper and form. And so I guess we do, but how do you go about enforcing that or making just the words come into reality? So the spirit of the law, as one gentleman was saying earlier before, how do we make that spirit of the law come into reality?
That's a good question. I'd love to receive more feedback from your audience on that particular issue. I'm open to suggestions myself.
Yeah, it is. It's the deepest, a great question. Any callers that would like to make any comments or ask any questions, the dialing number is 310-982-4184 and dial 1 from your dial pad, 310-982-4184. And we're going to tune in from a comment from our listener, 7188. You're on the air.
Yes. Sorry about that. Well, my concern in what we do with the think tank, I'm always concerned about law when it comes to politics, with law, period. And for the think tank to achieve what it needs to achieve in the African American community, what I'm embracing is law, period. That's a very important part of our of our life, especially being African Americans or any minority in this country. And we need to invest in that, as far as I'm concerned. And that's my main point today.
So, if we are going to be investing in law, how do you think that we need to invest? What do you mean by invest in law?
Well, when it comes to me, I think that every church, every African American church on Sunday should take out at least 15 to 30 minutes talking about law, because it affects our community so much. Are we getting ready to vote? A lot of our people don't understand how voting works, the civic engagement component. And for us to be able to move forward, we have to invest in that. And I mean, put the time in. We have to educate everybody. I mean, from the babies all the way up to the seniors. And we need to make time available during the week for that. Because once we understand law, economics in our community will increase. Because the laws determine how where we live, how much we pay for houses, the whole 9 yards. I don't want to take up too much time. But once we embrace that education, and education is very important here, we can move forward as a community. As far as the African American Economic Recovery Think Tank, that's one of our main components, and that was fall up on the family infrastructure that we need to do in America in order for us to be a powerful nation within America. Thank you.
Thank you for that comment. I agree as well. It is important to capture our attention, the places that we are congregated at in the masses of numbers, in order to give us instruction and the information that's needed. Honorable Al Bey, I wanted to ask you a question about the other affiliates. So, we have learned about your different affiliations and memberships in your bio, but the other affiliates are numerous trusts and other secured party entities. Could you explain to us what type of trusts are affiliates and what is the secured party entities? Could you clarify that?
Nonprofit organizations, numerous trusts. So trusts are normally, they can be corporate or they can be private, and so I deal with both.
And secured party entities, what is that, or who is that?
Banks. I deal with banks and community investment funds.
Okay, great. And we're at the closing at our show in a few minutes, so I'm going to leave you with about 60 seconds of final thoughts.
I wanted to say thank you to each and every one of your callers and participants for their time today. And I would love to be of service to any and every one of them, but know above all else, be of service to self. Stay studied and, keep listening to this wonderful blog and hosted product.
Well, thank you so much for being a guest on our show today. Again, this is the Honorable Al Bey Esquire and Affiliates, and you can go to their website at attorney-in-fact-assistance-league.com. That's correct, right? I got it right?
Yes, ma'am.
Okay, great. So, attorney-in-fact-assistance-league.com for ADR services. He offers forensic discovery so that you can get a breakdown of your case, fact-finding, merits to the claim, along with laws and codes to give you the different alternative dispute resolutions that you have outside of litigations, and the laws and to support it, and the references that you can go to. It is a very unique tool that you can utilize. Attorney in Fact Assistance League also offers their assistance to victims of malicious prosecution, so you can always go to the services tab for those of you that are familiar there and didn't know that it was added on to. There is an option under services under victims of malicious prosecution.com's website under services, where we are offering alternatives to this crazy life. I thank you all for being a guest on the show. I thank the callers for the comments that they had in. And until next week, everyone, thank you for being a guest and listening into Rachamah's Conscious Couch. And you know how it goes. In the meantime, in the meanwhile, get off of my couch.